Now, the Supreme Court rules in a case involving free speech, security, and a former vice president. Margaret Warner has the story.
The court ruled unanimously today to shield two Secret Service agents from being sued on First Amendment grounds by a Colorado man arrested after he confronted then Vice President Dick Cheney in 2006. The man argued he'd been arrested because of critical remarks he made about the Iraq War. State harassment charges against him were ultimately dropped. In an 8-0 decision, the High Court overturned an appeals court ruling that had allowed the lawsuit to go forward. To help us sort through this, we're joined by Marcia Coyle of the National Law Journal. Marcia, welcome back.
Thanks, Margaret.
So what happened in this encounter between Vice President Cheney and this man involved?
3 Secret Service agents with Mr. Cheney at the mall began watching Mr. Howard's because one of them had overheard a cell phone conversation in which Mr. Howard said he was going to ask the Vice President, "How many kids did you kill today?" Mr. Howard eventually did get to Mr. Cheney, and instead he just told him that he thought the administration's policies in Iraq were disgusting. The Vice President thanked him. As the Vice President turned to leave, Mr. Howard touched him on the shoulder. There's a dispute whether it was just an open-handed pat, as Mr. Howard claims, or a push, as the Secret Service agents claim. The Secret Service agent, one of the 3, then went and spoke with Mr. Howard, asked him, "Did you assault Mr. Cheney?" He denied that, asked him if he had touched Mr. Cheney. Mr. Howard falsely denied that.
So the man, Mr. Howard, argues that he was arrested instead because of his views.
Exactly. His claim, after the charges were dropped, was that he was arrested in retaliation for exercising his First Amendment speech rights.
And law enforcement, the Secret Service said?
They said that they had what is known as probable cause, more than a good reason to arrest him. He had lied to federal officials.
So what was Justice Clarence Thomas, writing for the majority, what was his ruling on why he agreed with the agents, or to what degree he agreed with the agents?
First of all, he said we're not talking about a general First Amendment right to be free from retaliation for one's speech. He said what's at issue here is a very specific First Amendment right to be free from retaliatory arrests, an arrest that is otherwise supported by a good probable cause reason. He said that at the time this incident took effect, the Supreme Court had never recognized that kind of a right, and it also wasn't clearly established throughout the land that such a right existed. And because the law was unclear, you could not hold the Secret Service agents responsible or make them go through a trial in which they faced monetary damages.
So what is the practical effect of this ruling, and how broadly does it apply if, say, whether it's Mitt Romney or President Obama or any other public officials out there, the Secret Service is not only involved in protecting him or her, but a lot of local law enforcement and state law enforcement gets drawn in. Does this case change how they need to operate, what they can take into account?
Well, I think probably, first of all, it's a very good decision for these 2 agents. But there was a lot of unhappiness among state and local law enforcement officials because they wanted a bright line rule from the court. They wanted the court to say this type of right doesn't exist. Law enforcement,
the right to sue,
right, for First Amendment retaliatory arrest, so that law enforcement officers would know, when they would cross a line, and this was not a line that they could cross. The law is still unclear. The Supreme Court hasn't recognized a right. All we know is that in 2006, the right was not clearly established.
So, Marcia, before we go, this is June, traditionally the last day of the court. Fair to say we're still awaiting some really big rulings.
Right. We have about 3 weeks left in the month, or almost 4 weeks left in the month. Everybody's watching, obviously, for the health care ruling, the challenge to the new federal health care law. There's also a lot of interest in Arizona's very tough immigration law and what that might mean for other states with similar laws. But there are also a number of very important decisions. For example, there are 2 cases involving the constitutionality of imposing life without parole on juveniles under age 14 who commit murders. There's a major challenge to the Federal Communications Commission's regulation of indecency on television, and also a First Amendment challenge involving the federal law known as the Stolen Valor Act.
And I understand that there's also a case that would give the court an opportunity, perhaps, to touch on Citizens United?
The court on June 14th is going to take its first look at an appeal, a petition that's been filed by 3 corporations who are challenging the Montana Supreme Court's decision that its law banning corporate independent expenditures survives despite the Supreme Court's ruling in Citizens United. It's going to be very interesting to watch how that plays out.
Especially in an election year.
Absolutely.
Marcia Coyle, thanks so much.
My pleasure.